Well, good evening, everybody. My name is Jessie Quilty. I'm a senior housing investigator with the Arizona Attorney General's Office Civil Rights Division. I have been with the division for approximately, going on 13 years. Started out as a volunteer mediator with the Civil Rights Division and then joined the staff in 2004 as an investigator. And my primary focus is fair housing. So just kind of give me an idea of all of you. How many of you currently reside in HOAs? Okay, well, most of the room here. And how many of you have served or are currently serving on your HOA board? Okay. I also served on my HOA board for about 4 years. 3 of those were as president. So I certainly got to learn the inner workings of the incredible amount of responsibility and service involved in being on the board of directors. It also had an additional perspective, and that was from the fair housing perspective through my day job with the Civil Rights Division. So for those of you who are residing in HOAs and or serving on your boards, I hope to make this presentation relevant to the work that you're doing in addition to the general overview. Okay, the Civil Rights Division's role with regard to the Fair Housing Act is the Civil Rights Division enforces the Arizona Fair Housing Act. Now, many of you may be more familiar when you hear Fair Housing Act. Yes, we do have an Arizona Fair Housing Act, and every state has one, and it substantially mirrors the federal Fair Housing Act. The Civil Rights Division also simultaneously investigates the state and federal claims of housing discrimination. That means when a discrimination complaint is filed with the division, it's dual filed with HUD, and we investigate both on behalf of the state as well as the federal. Now, what is a civil rights complaint? On what basis is one filed? Essentially, that is when an individual pertaining to, say, HOAs, an individual in the community feels that they have been treated differently than others not of, for example, others not of their race, their color, national origin, sex, disability, religion, and also can be in familial status. Now, familial status is when there are minor children in the home under age 18. And out here you may see retirement communities, perhaps like over in the Sun City areas. Perhaps there's some, closer to this direction. Retirement communities that familial status generally does not apply, because if there's no children under 18, then it wouldn't apply there. Another basis is retaliation. If one has complained of discrimination to their board of directors, for example, and then they experience adverse action following that complaint, that can be basis for filing a civil rights complaint, a housing complaint. Also, if the individual has filed a fair housing complaint formally with the Civil Rights Division and has had adverse action directed at them following that formal complaint, that can also be a basis for amending the complaint and adding a retaliation allegation. Okay, so who can file a complaint of housing discrimination? Well, there's several modes of which this is brought about. One is that a complaint may be filed on or behalf of a person claiming to be harmed by discrimination. Typically where we see this is in situations where an individual is disabled. Say there's an individual in a household who has a disability, a family member or even a caregiver can file a complaint on their behalf. Also, any person, agency, or organization may file a complaint on behalf of a person claiming to be aggrieved by a discriminatory housing practice. You might see an advocacy organization file a complaint on an individual's behalf. And again, in the earlier example, an individual related to the individual, or even a friend. A complaint may also be filed by the Civil Rights Division. the division does have statutory authority to initiate a complaint if they see something in the public interest. So how does one file a charge of discrimination with the Civil Rights Division? In other words, how does all of this come about? How is a complaint initiated and might end up on your doorstep? First of all, we have 2 offices, one in Phoenix and one in Tucson, that individuals may contact for initial screening of the complaint. Typically, individuals will call our office. We will set up an intake appointment for them to come in and go over the details of the complaint. We will assist them with filing that charge, or we may take the complaint over the telephone and send it to them for signature. Individuals also contact the division by filing a discrimination questionnaire online. We have an email address. People send complaints to us all the time. And we will go through that and contact the individual. And persons living outside of the metro areas of Phoenix or Tucson may be interviewed by phone and file the charge over the phone and have it mailed to them. Okay, time limits. The Fair Housing Act, whether it's state or federal, does observe what's called a statute of limitations. That is 1 year from the last date of harm. Okay, so whenever the discriminatory act is alleged to have occurred, individuals have a right to file up to 1 year from that date. Now, whether one has met the 1-year deadline by filing an online questionnaire, well, there's several aspects of that the division takes into account to meet the criteria. One is after the division reviews the questionnaire and contacts the individual who submitted it, they will draft a complaint for review and signature of the complainant. That's assuming it's got in within the 1-year time period. In cases where perhaps sometimes this happens, believe it or not, people contact us they call us on the 366th day. But they say, you know what, I sent in a complaint three days ago online, and what we will do is review the questionnaire to ensure that they have provided substantial information, or what do we call it, not substantial, but minimally sufficient information that they have articulated a discrimination claim. If that is the case, we will deem the complaint filed that day, even though our contact was after the 1-year period. Okay, so what do people bring to an intake appointment? What information is provided to the division in order to file that complaint? Well, obviously, who is the complaint against? Where are we sending the complaint? So the name, address, telephone number, and or email address for the housing provider and any potential witnesses. Now, housing provider, maybe that's something you think of in multifamily housing where there's apartments. Housing provider is very broadly construed. That also includes HOAs who enforce CC&Rs on a regular basis. Documents showing communications with the housing provider or housing entity related to the discriminatory conduct. I tell you what, email and text messages are great. We know exactly what was said, what was the communication with the property management company or the HOA board members. The complainant may also bring other documentation of discriminatory conduct, such as advertisements or photographs. Advertisements could be, say, a rental, no children. Okay, they bring that in with them, so we might have direct evidence in that case. Now, the question often comes up by an individual, must they also contact HUD to protect the rights under the Fair Housing Laws? HUD, of course, enforces the Federal Fair Housing Act. The answer to that is no, because when an individual contacts our office, the complaint is automatically dual filed with HUD. Okay, so when is a respondent notified that a complaint has been made? For those of you serving on your HOA boards, if an individual from your community files a complaint of discrimination, once they sign off on that complaint, the division will be sending you notice of that complaint within 20 days of the date that the complaint was filed. Now, the response is that the division does request the housing entity to send a verified position statement, essentially answering to the allegations in the charge. In other words, the reasons behind the way the decisions were made. And a verified position statement, what that means is that at the end of the information you're providing to the division in response to the discrimination complaint, it essentially says, under the penalty of perjury, the foregoing is true and correct. We consider that a verified position statement. So we do request that within 14 calendar days of the receipt of the complaint. What happens after the housing entity receives notice of the complaint? The respondent submits a position statement, as we just talked about, and verified by the person with personal knowledge of the information in the statement. Oftentimes, that can be from the property manager, or not uncommon, we get it from the president of the board. Now, there are certain investigations are a step process. Okay, so we have somewhat of an order of tasks that we follow. Generally, the division will schedule an interview with the complainant to review the information in the position statement. So they get a chance to respond to a position statement. They show us where the gaps are. There's opportunity for the complainant to give us more details, perhaps names of witnesses, and that type of thing. The complainant may also request to review the position statement beforehand. Okay, so it's important that when a fair housing complaint is received, that folks understand that that information will be reviewed by the complainant, of course, as well as the division. Now, each case will require a different type of investigation. How, say, for example, a familial status discrimination complaint would be investigated could be very different than a disability related claim. For example, familial status, we might ask to see what are the rules in your CC&Rs or your community policies pertaining to children activities on the property. Disability discrimination complaint, we may ask to know is there anybody in the community who has requested an accommodation for their disability, some type of modification or an accommodation. And we may go to those individuals to verify what you've presented. We also obviously interview witnesses for the complainant and the respondent. Just as the complainant says, hey, Mary Smith and Joe Sanders are first-hand witnesses to this situation, respondent may say, I'd like you to talk to my property manager or my board treasurer. They had interaction with the complainant. So we interview witnesses for complainant and the respondent. And the respondent is the entity receiving the complaint. We will also conduct an on-site investigation, and I would say 99% of the cases. So we're going to take a look at the property. Oftentimes we'll review files, and we'll talk to individuals that reside on the property. Now, what happens at the end of the investigation? This is a question that comes up every single case. People want to know. So what's the result of all this? Well, there's always one of two outcomes that occur when the case has gone to a full investigation. One is that the investigation didn't substantiate the allegation. We don't say that nothing occurred. We say that simply there was insufficient evidence to substantiate the allegations, and therefore the division dismisses the case. However, the individuals have a right to request reconsideration, which means that they'll put it in writing within 20 days of getting a dismissal letter, and they'll say, well, I feel maybe there was some evidence not investigated, or I have some new information I would like looked at. At that point, the division will review, folks not involved in the investigation, attorneys not involved in the investigation will do a thorough review of the case, and then they will make the decision whether it should be reopened for further investigation. In addition to that, the individual may file a private lawsuit against the housing entity, or the HOA. Now, the other outcome is what's called a reasonable cause finding, and that's when there's reasonable cause to believe that discrimination occurred. i.e. violation of the Fair Housing Act. The division will make efforts to obtain voluntary compliance with the fair housing law through post-finding conciliation. Now, when what we call a cause finding is issued, what you would receive in the mail is the facts, okay, a list of facts, and the conclusions of law, why the division has reasonable cause to believe that there was a violation of the Fair Housing Act. With that, at the end, division invites the parties to join with it to conciliate the case, and that's what we call voluntary compliance. Now, there's other options when a complaint has been filed for resolving a complaint of discrimination. One is mediation, where a neutral mediator trained by the Conflict Resolution Unit of the Civil Rights Division assists the parties in resolving the dispute. That's what we call facilitated mediation. Some of you may be familiar with that process. It can be really a wonderful process. I started out as a mediator. It gives the parties an opportunity to come to the table and discuss the issues in dispute and see if they can resolve it on their own terms. The division is the third leg of that agreement, so we will sign off on it. And so that's one method, and it is strictly voluntary. So parties volunteer to be part of that process. The other is what's called pre-finding conciliation. Those cases, when they can be, a lot of complex facts in dispute, it may be routed to conciliation, where one of our assistant attorney generals will sit down with the parties or talk with them over the phone and find out, what are the facts. They review the file and they assist the parties in coming to a resolution. Another way is what's called voluntary withdrawal with resolution, and that is, and I'll give you a prime example of that in HOAs, where, for example, let's say the HOA has a parking restriction, okay? Individual needs to park the car out on the street in order to have safe ingress and egress out of the house because there's a family member that's in a wheelchair. HOA says, no, you can't park on the street, we can't make an exception, even though the individual explained that for reasons of disability they needed to park on the street. Well, what will happen sometimes is once a complaint's filed, the complaint can kind of wound its way up to maybe higher level decision makers, or maybe more thoughts given to it. HOA contacts an attorney, gets a consult, and then the HOA says, you know what, I think we can make this exception in this case for reasons of disability. Well, what will happen is that the complainant will contact us and say, I've got it resolved. There's really no reason to continue an investigation. So they will request to withdraw the complaint. And that's great when that happens, because people are talking to each other and they're getting it resolved. Now, if parties settle privately, such as with an outside agreement, and that does happen, will the division end its investigation? Well, as we discussed before, the complainant would file a withdrawal form and provide information about the reasons for the withdrawal. We got it resolved. Some people literally put, I just need to get on with my life. I no longer want to pursue this. I don't have the energy to pursue this. And so they might withdraw the complaint on those terms. However, the division chief counsel will review the reasons for withdrawal. If it's a matter of great public importance, then the division certainly may continue to hold that file open and conduct an investigation. Now, for those cases, reasonable cause determination is issued. If it's not resolved anywhere along the way, such as pre-finding conciliation or post-finding conciliation, then the division is required to file a lawsuit in Superior Court. At that point, it is the state versus, for example, the HOA. However, the complainant certainly may hire their own attorneys or pro per. They could become parties of that lawsuit as well. The purpose of the lawsuit obviously would be to seek remedies for the victim of discrimination and to stop the discriminatory activity. Again, the division in all cases represents the state of Arizona, but others may join in the lawsuit. Now, this is a question that often comes up in investigations from respondents, is say, for example, if the complaint is dismissed, is that the end of it? Well, not necessarily, and this is why. A person may file a housing discrimination lawsuit, first of all, without even going through the division. So you may find out about the grievance that way. And even if the person has filed a complaint with the HCRD, they may initiate a lawsuit against the housing entity or the HOA. And a person has 2 years from the last date of harm to file that lawsuit. Now, what kind of remedies result from a finding of discrimination? If it goes to lawsuit or even in settled cases, what kind of remedies might be asked for? Well, one is actual damages. That could be expenses out of pocket. It also includes emotional distress. Punitive damages, injunctive and affirmative relief. Policy changes, that's a big one that we see with HOAs, is when a policy is discriminatory in nature, the division will likely seek to work with the HOA to change that policy towards compliant with the Fair Housing Act. Also, housing provider training. We ask HOAs to get fair housing training so that you have more knowledge going forward about what the fair housing obligations are. Sometimes permanent and temporary restraining orders enjoining a defendant from engaging in the discriminatory housing practice or transferring property. Not HOA related, there was a case where an individual didn't want to sell his property. He had partitioned off the property. He didn't want to sell it to a black family. And one of the things we did was, go into court to ask the court to stop him from selling that property to anyone else until it went through the process. So that is something that the division can do. And that's what we call temporary restraining orders. Also, civil penalties. If a housing entity has violated the Fair Housing Act, we can ask the court to apply a civil penalty. That is essentially a fine. And of course, attorneys' fees and costs to reimburse the division for their work, and certainly complainants who are represented separately by their own counsel, they can also request attorneys' fees and costs should they prevail. Now, to give you some current statistics, fiscal year 2012, our fiscal year for the division runs July 1st to June 30th of every year. We have many complaints filed, however, we count for that fiscal year, we count the investigations that are completed during that time period each year. In fiscal year 2012, the division completed 157 fair housing cases or fair housing investigations. 46 of the 157 complaints that were filed, or 29%, were resolved by settlement or conciliation. So that really is a fantastic process for parties to avail themselves of if they so choose. It gives them an opportunity to largely settle it on their own terms before a decision is made for them by the division. Also, 140 of the complaints listed one protected class or basis for the alleged discrimination. 17 listed 2 or more bases. I had a fair housing case back in 2006 that the complainant actually listed 3 bases, and that was national origin, religion, and retaliation. Okay, so that was a very complex case to investigate. They were Middle Eastern from Egypt. They found that the division found that there was a discrimination that occurred. It got settled on the eve of the lawsuit for over $200,000. Now, the breakdown of our cases last year, it might surprise you. I know it always surprises me because I always think in terms of that we have a high number of race complaints, but that's actually not the case. In the last few years, what we've seen really spike is the disability discrimination cases. Out of 157 cases, 104 of those were disability claims. 29 were race, 11 retaliation, 11, sex or gender, 10, national origin, 6, familial status, and 2, religion. Where are the areas, what are the cases that we predominantly see HOAs, filed against HOAs? It's always important to understand that this includes, but is not limited to, okay? Terms and conditions. If you're enforcing CC&Rs, people can perceive that you're coming down heavy-handed on them, but their neighbor who has left their car out on the street has never gotten a notice. Well, it could be that the board member wasn't up at 3 in the morning to do a parking compliance tour and wasn't aware of it. However, it's those types of terms and condition complaints that get filed with our office. Another area is disability. That is actually something that a lot of housing entities struggle with, and the reason for that is that the needs are so specific to the individual disability. When should a housing entity or an HOA board grant an accommodation or give approval for a modification? The more fair housing knowledge you can acquire and in consult with attorneys who are familiar with fair housing, that can be resources to you. And also property management companies, they tend to want to represent you in all aspects. If you are interviewing property management companies or you have one currently, you may want to ask them, what do you know about fair housing? If we get a fair housing complaint, I want to know what steps you're going to take. I once investigated an HOA that the first time the board president learned about a fair housing complaint was when she got the legal bill from the property management's law firm. And that was like 2.5 months later. So talk about a board feeling like they didn't have an opportunity to be involved in whatever the situation or the grievance was, okay? So you want to ask those questions of your property management, and if you're securing one, make sure that you've asked them what they know about fair housing. Do they have an attorney that they consult with or that they retain, and what do they have expertise in fair housing? Because sooner or later, if you're going to be involved in housing, you may get a fair housing complaint. There is a difference under disability-related requests between reasonable accommodation and reasonable modification, okay? Reasonable accommodation is an exception to a rule or policy that you might have in your CC&Rs or your community rules and publications. That is an accommodation. A modification is when you're actually redesigning something, where you're lifting up striping, you're redoing the route of travel, that type of thing, putting up a different sign, perhaps making a new ingress or egress. That is reasonable modification, and this is something that just stumps people everywhere. When it's reasonable modification, the way that the Fair Housing Act is written, it is the individual homeowner's responsibility to pay for that modification. But boards, the inquiry will come to you first, and it's your responsibility, of course, to give it due consideration and see if it's a modification it can be safely made, and if the person offers to pay for it, give them consideration to do that. Now again, those decisions are made in conjunction with your legal counsel and making sure you're getting appropriate legal advice. But under the Fair Housing Act, if it involves a redesign of something, that is a modification. The homeowner is required to pay for it. And that doesn't go over well, I can tell you that. I have to be the bearer of bad news to a lot of people who call because they're like, well, I can't afford this modification. Well, that's the downside of the Fair Housing Act, but they are required to pay for it, not the HOA board. The thing to remember about the ADA people is that ADA works with businesses, places of public accommodation, where the business is required to provide all kinds of accessibility. When it comes to the Fair Housing Act, that's not the case. Homeowner makes the request. If it's a modification and it's reasonable, they pay for the modification. Many people became inadvertent landlords when they ended up with an extra house during the recession, or they just have one house to rent. The Fair Housing Act does have an exception. A homeowner must have, if you're renting properties, must have 4 or more houses, including the one they live in, to be subject to the Fair Housing Act generally. Now, granted, if it's sexual harassment, you may have one house and there likely will be a complaint and investigation. If there's retaliation related to sexual harassment, then that falling under sexual harassment, you likely will get a complaint and be investigated.
Good evening, everybody. How's everybody doing? Good. That's good. My name is Stanko Zovko. I'm with the Southwest Fair Housing Council. We are a nonprofit organization. We do education, advocacy, and enforcement of fair housing issues. We're a little organization. We're grant funded. We have offices here in Tucson and then closer here in Phoenix. We work with communities regarding fair housing issues. We do enforcements through what are kind of like mystery shoppers. We look to housing providers, see if they treat people differently regarding different protected classes. We do advocacy for people. If they have complaints or want some mediation with housing providers, we can become their advocate for that. And then we also do education outreach to housing providers. That's my position. I specifically do education outreach. So this presentation is going to be just our basic Fair Housing 101. What is law? How does it apply? Who is protected? So the Fair Housing Act is a federal law that prohibits discrimination in all aspects of housing. Really anything that touches housing, is affected by the Fair Housing Act. So any kind of rentals, homeowners association, even zoning codes, everything that has to do with any kind of housing falls under the Fair Housing Act and under that jurisdiction. Generally, we see these kinds of posters. We like to see these in the community. It shows that as a property owner or as an organization, you support fair housing. So if anybody provides a rental, they are required to provide a copy of the Arizona Residential Landlord-Tenant Act, or to provide information as to where that people can find it. These are the websites available. So the state has its own Fair Housing Act that closely mirrors the federal Fair Housing Act. First of all, when talking about any kind of rule, it's good to talk about the exceptions, because like any good rule, this rule has several exceptions. It was touched on a little bit earlier. If it is a single-family home with no advertising, or if it's 4 or fewer units that an owner has and it's owner-occupied, like a fourplex, there's a very rarely used law known as Mrs. Murphy's Law that allows an exception to the Fair Housing Act. Other places that are exempt are things like private clubs, religious organizations. A monastery can choose to only rent to monks. Private clubs can have their membership only and have people meet those requirements. And then also senior communities have exemptions in regards to laws and regulations regarding children. So some background, the Fair Housing Act started as a Civil Rights Act. Shortly after Martin Luther King Jr. was assassinated, the Civil Rights Act grew to include housing as well. In the 90s, they added disabilities, the Americans with Disabilities Act, which covered some more physical structures and accommodations that needed to be made. So what is protected under the Fair Housing Act? There are 7 classes that are protected at the federal level. The first being race. You have your classic examples of segregation, people refusing to rent to people that have a certain ethnicity or background. Color can happen within a single race. You have different shades of people. People still discriminate against that. National origin, we see a lot in our organization. That has to do with where you're from. So generally, people won't provide resources for people with limited English proficiency. You have discrimination as far as what types of documents are required. We work mostly with housing providers, so we'll see things like people will ask for something like a social security card as proof of residency in this country. Not every resident has a social security card. These kinds of restrictions and these kinds of rules can be viewed as restricting people based upon national origin. Anytime you encounter limited English proficiency, there's all sorts of resources out there to provide proper help and accommodation. My father he moved here 30 years ago. He still probably speaks 40 words of English, but he still gets by, and people make accommodations for him. You know, especially now with newer technologies, there's all sorts of avenues to go to. So sex, we see this sometimes. This is treating a man and a woman differently. So we have a lot of HOAs here. Let's say I'm an HOA president. You know, then this can go both negative and positive reinforcement of either class. So let's say I don't necessarily enforce my parking standards on all the cute girls in the HOA, something of that nature. So it can be both deemed in a negative term or positive term. If you favor one type of people over another, not necessarily just enforcement, you know, just not necessarily just negative enforcement. And generally, you come into two types of sexual harassment. You have your quid pro quo, literally one thing for another. So, you know, maybe you have on-site maintenance, something like that. They choose to fix somebody's water heater quicker than somebody else's in exchange for some type of sexual favor. We see it. It happens. It sounds ridiculous. We have harassment. So harassment is specifically judged by how the actual individual target feels. You know, some things people might consider ordinary, might consider playful. The harasser, they might consider that they're totally within their social bounds, but that's really for the target to identify. We had one situation where a property owner was fully exposing himself to the tenants. I don't think under anybody's personal opinion that's proper, but you'd be surprised. This happens a lot. Familial status, the way that we see discrimination against this, generally with rules for children under the age of 18. So some communities might inadvertently discriminate. They have good intentions. You have communities with rules such as maybe they have the intention to have a swim area open for adults so they can exercise. So they say no children between a certain time frame. They can have it the entire other, you know, 22 hours a day, but just these 2 hours, 10 to 12, are blocked off just so adults only can swim. You have to be careful with how you word the rule. You know, you have to address behavior, not the person. Anytime you show any kind of restriction on what kind of people can use your amenities, that's where you run into trouble. You know, maybe instead of no children, you enforce a lap swim only time, where, you know, you enforce the behavior in the amenity, not who can actually use the amenity. So you have to make a clear distinction every single time. Rules that generally serve health and safety are okay. You know, if there is a true danger to the health and safety of the children and the rules dictate that, that is fine. But restricting behavior for certain people or restricting access to amenities for certain people, that's where you run into troubles. So another way we run into it would be through occupancy policy, and that was a question earlier. On the federal level, there's no occupancy policy. The state has, the Arizona Landlord-Tenant Act considers 2 people per bedrooms as reasonable. HUD generally grants an additional exception, and there's a lot of ways that this can be enforced. So generally it has to do with the structure. If you have like an extra area that can be used to house a person, office, a den, there's also health and safety concerns that come into this as well. Maybe, you know, maybe a property has a septic system that can only handle so many people per residence. That's where that safety concern will override that occupancy concern. They're not discriminating based upon familial status. They're discriminating based upon the actual safety and health of the property and the community. We had there's a case where a grandmother was living with 3 grandchildren, and in a 2-bedroom, she was asked to upgrade to a 3-bedroom because they had a 2-person occupancy policy per bedroom. Part of their policy was that guardians can't share a room with the children. You never want to dictate who lives in the rooms, just your total occupancy policy. So that complex was wrong in doing that and restricting that and enforcing that. And sometimes Before we jump into disability, oftentimes you want to check with your local ordinances because sometimes additional classes are protected. There's additional ramifications. Tucson has added 5 additional classes that are protected. The city of Phoenix has added sexual orientation as well as a protected class. So you get your 7 on your federal level, and then you can have additional as well on your local level. Now, disability, what constitutes a disability? So it's a 3-pronged definition, and people can qualify for disability in 3 ways. The first is a person with a physical or mental impairment that substantially limits one or more major life activities. Now, this can be both visible and invisible. Your classic example of your visible disability would be like an amputee, maybe somebody with limited mobility in a wheelchair, somebody can't get around. That's oftentimes evident. You can tell that just from visual contact. Where people run into difficulty is through invisible disabilities. That can be a mental disability that might not be apparently evident when you first see somebody. So you always want to be careful when talking to people and they're asking for accommodations in regards to disability. So major life activities. I can't do half of these before I drink coffee in the morning, but that doesn't mean I'm disabled. People have to have an ongoing condition for this. The second way somebody can qualify for a disability is having a record of a disability. So some examples of this might be somebody who has cancer and is in remission. They're not actively impaired by this, but they have a record of a disability. Somebody with a heart condition, something like that. And the third prong is a little bit more conceptual. It has to do with perceptions and stereotypes. So maybe somebody, like an example that we often give is maybe a woman was in a car accident and her face was disfigured. She still has all of her life functions, she can still get around, but in her interactions in society, she is treated in a way and regarded in a way that she has a disability. So this has to do with perceptions and stereotypes, how people interact with you. A long time ago, people, when they didn't know about how HIV was spread, a lot of times the people that worked in the clinics were almost ostracized in a way. People were very negative towards those people and restrictive in their uses and actions. That falls under this class as well. So let's say you have a disability. What can you do? You can do one of 2 things. You can request either modification or an accommodation. Now, the modification has to do with the physical realm. So this would actually be a structural change. Generally, the conditions are the tenant or resident pays. It has to be done in a work person-like manner, and there's a potential that the person might have to put up money in escrow for restoration. So work person-like manner, if somebody's asking for grab bars and they're saying build down the street, he has a power drill, he can put these in for me, no problem, that doesn't count. You need an actual professional to install it. And restoration, if you're a housing provider and they're asking for an accommodation or a modification that might be detrimental to the next person living at the property, let's say somebody who's in a wheelchair all of a sudden lowers all their cabinets 3 feet so they have access from the sitting position, that can be a hindrance to the next person who occupies that property. They might have to put up money for escrow to have that restored after they leave. Now, the other thing that you can ask for is an accommodation. And this is not in the physical realm. This has to do with policies and procedures. So maybe you have an association fee that's due on a certain day. And you have maybe a veteran who's receiving disabilities. His pay date is changed. He's asking for an accommodation in your procedures to waive the late fee. He doesn't get paid until after the due date now. So you want to look at everything when they're asking for an accommodation. Generally, it should be cost neutral. So, an association isn't necessarily losing any money, but not receiving this payment on this day, receiving it a few days later. That late fee is not going to make or break you. Generally, you want to look at a cost neutral situation. We had a situation where we had an elderly woman who was asking we had a complex that had one of the waste disposals with the bigger units, the dumpsters, where you flip open the top and you toss it over the edge. She had arthritis. She couldn't handle the trash. She couldn't lift the lid, more or less, lift the trash over the lid. So she was asking for somebody to come to her property every day to take her trash to the dumpster. The on-site staff only had maintenance 2 days a week, and they said, sure, Tuesdays and Thursdays, there's no additional cost to us. We can have somebody stop by your property and empty that. You know, she complained. She said, I need it every day. You know, I can't live in here with this trash. I need it emptied out every day. You know, that's where they can't hire on more staff and additional costs to accommodate this person's request. That's where you want to come to some kind of mediatory resolution on that. So when somebody requests accommodation, they are required to have two parts, verification and connection. So verification would be something generally from a medical provider. That definition can be expanded more to include, but generally it's from a medical provider or healthcare provider. And then you need a connection with the disability. So if somebody's asking for, you know, let's say somebody's asking for accommodation based upon limited mobility, but you can see that they're walking fine, you know, you want that connection. You want to ask, like, why do you need this ramp? Why do you need this? You know, you seem to be getting around pretty well. Landlord must grant the request unless it's too difficult or expensive, called an undue financial burden, or it would be completely outside the normal course of business, called a fundamental alteration. You know, you always want to work towards a resolution. We kind of recommend a few different steps to come to a good conclusion on these. First of all, take a breath. You know, people are prone to saying no or yes right away to requests. You always want to review everything. Respond to every single request. You're required to. If denial, is there something else that can meet the needs of the resident? Maybe that woman with the trash, maybe her issue wasn't necessarily the trash, maybe it was the smell. Maybe she could place her trash outside in like a common area where the maintenance staff can still pick it up twice a day. You know, oftentimes people have there are solutions available that people aren't necessarily aware of. And it's up to both parties to kind of come to that conclusion. You know, if they have difficulty, they can come to advocates like us, the Fair Housing Council. And these are examples of some of the kinds of requests that we get. You know, it runs the gamut from grab bars to parking spots to people have asked for personal attendants to help them get dressed, things like that. I mean, you will, if you're a housing provider, you will come into contact with a lot of different types of requests. One of the most common requests would be an animal request. So looking at this, which one do you think should be charged a deposit? The reason I have this slide up here is because people tend to use terms interchangeably. So what's a service animal to somebody might actually be an assistive animal, things like that. People use terms that they might not necessarily be comfortable with or might not know the true definition of. So when it comes to fair housing, you have to think of a pet as a tool. So like if you have any kind of restrictive policies against pets, once they are actually a certified assistance to somebody with a disability, you have to consider them a tool. All the rules that apply to pets might not necessarily apply to these tools. So some of the rules, you know, oftentimes communities have rules and restrictions on size, on breeds, you know, no pink leashes, they're too gaudy, things like that. Those go out the window when you're talking about tools. But rules that regard safety and health, you know, of other residents, things like leashes, picking up animal waste, you know, having shots and tags, those are still applicable. You know, once their right to have this accommodation doesn't infringe on other people's rights for their health and safety and welfare. And that's what those rules are meant to be. ADA regulations, they are about the public realm. So you're talking about your restaurants, you know, the bus, you know, anything in the public realm. When you're actually talking about your your actual residence, that's where fair housing comes into play. So the ADA defines a service animal as a dog or a miniature horse. You can buy a guide horse if you'd like. Some people prefer these. They actually live longer than dogs. They have less dander, I believe, and they're kind of neat. But as far as like an actual assistive animal, by FHA guidelines, it could be anything. You know, it could be a snake. It could be, as long as there's verification and connection. You know, if you don't believe somebody's providing legitimate verification, it's up to you to you know, contact the police or something like that, file an investigation. It's not up for you to just deny that claim. You know, if you don't think somebody's accredited or a medical provider for whatever reason, that's not for you to determine. That's for, you know, the police to determine. Now, generally, when you're talking about fair housing, there's 8 prohibited practices. So refusing to rent or sell or to negotiate for the rental or sale of a dwelling. So there was a situation where a woman was asking to rent a property. It was a fixer-upper. The owner had several properties, and he said, ma'am, do you have a husband? Because this is kind of a little bit more work. Let me show you this other property that I have. He refused to show it to her, the fixer-upper, based upon an assumption of one of the protected classes. So he was actually fined for it. Subjecting persons to different terms, conditions, and privileges. So, you know, maybe you look the other way on certain fees for certain people. Maybe we have a property owner, you know, Mario, he loves his paisanos. He's like, hey, you know, first month's free for all my Italian brothers. That shows favoritism. You know, charging different rates and having different conditions. Limiting housing choices by word or conduct. So that might be difficult. So because that's not explicit, that'd be something like, let's say a housing provider had, you know, a large property, and one side faces the dump, and the other side faces this beautiful garden. And maybe the residents that he was discriminating against, he showed them the side facing the dump, and he showed residents that he favored the side facing the garden. That's not an explicit discriminatory practice. He's not saying anything that might be construed as discriminatory, but his actions show it. So otherwise making housing unavailable. So let's say, you know, for instance, you had a multifamily housing, several buildings. You like to put all the students in one building, all the seniors in another building. You think maybe their schedules kind of line up more. I have less complaints this way about noise and activities. And then somebody comes by and says, hey, I'm a student, I want to live in this building. Well, our student one is full. We have spots in our senior one, but we're not going to rent you those. That's otherwise making housing unavailable. So misrepresenting the availability of a dwelling.
Can I ask a few questions about the apartment on Park Street?
What was your name?
My name is Juan Hernandez.
Been rented.
Hello, my name is Sanjay Kumar. I am calling about the apartment on Park Street.
It's just rented.
My name is Tyrone Washington. I'm calling about the apartment for rent on Park Street.
It's not available.
I use a wheelchair.
It's gone.
Hello, my name is Graham Wellington. I'm calling about the apartment for rent on Park Street. Is that still available?
Yes, it is.
What is?
Housing discrimination is illegal. If you think you've been a victim, call us.
So that's a nice little PSA that shows misrepresenting the availability. So another thing that comes into play commonly is making printed or publishing discriminatory ads, notices, or statements. Terminology comes into play here. So here we have some common terms used when advertising property or advertising a community. You know, these are architectural descriptions. Family room doesn't mean you have to have your family in there. You know, it can be anybody you'd like. Single family home can be occupied by, you know, you and your friends, or it doesn't have to be necessarily one family. Where you run into problems is when you start describing the kinds of people that can live there. Now, you see this a lot, and I'm sure if you've ever looked at ads for communities or properties, you see this all the time. It's hard to enforce this on a large scale, but once you start talking about the kinds of people that can live in a property, you know, great for young professionals, couples, families, things like that. Once you start showing favoritism in your ads, that's where it starts to come on this line. Discrimination on the basis of disability, classic example, a ramp is needed by an individual but it's denied by a housing association. And then retaliation, if somebody actually files a complaint and all of a sudden they get treated differently, they're asked to leave, they're assessed larger fees, they don't receive the same kinds of services, things like that would count as retaliation. One of the new things that comes into play with regards to housing laws in Arizona is the Medical Marijuana Act. So it states that no person can be denied housing for their status as a cardholder. That doesn't mean the landlord may not evict a person who uses medical marijuana on the premise. This is an issue that's going to come into play in federal court probably, because it's a contention between state and federal policy. But it's up to each community to kind of come up with their terms. If you have no smoking policies, they still come into play, things like that. HUD's opinion, they generally do not allow the usage on the properties that they fund. But each property owner must make a decision and put a policy in place. You think that you don't see discrimination very often, but this is from 2012, I believe. So here we had a situation where a girl was visiting her father and she used the pool. She was African American, she had some product in her hair, and it affected the pool. The owner had to pay for repairs, things like that. So to stop that, to prevent any kind of further damages, she put up this sign. And one of her arguments when it was questioned was that it was a historical sign. So it doesn't seem like a pretty good argument. In this point, she was addressing the person, not the behavior. This is not going to stop her problem. Other people have product in their hair, lotions on the skin, things like that. They still cause a problem. They can cause just as much damage to the pool. She's not really addressing her problem at all. She's just discriminating against a certain class of people. So maybe a better policy. She has a hose right there. Some communities ask that people rinse off before jumping into the pool, something like that. You really want to look at your rules and make sure that they're addressing behavior and that they actually address the problem, not the people. And you still see settlements. Some of them are pretty costly. You had the big one is the 800 units designed without accessibility features for ADA compliance. It's almost $1 million. So, the plan, the things you can do to avoid any kind of discrimination is just, it sounds simple, but you have to always consider it. Treat people the same by the rules and examine your rules. Make sure they don't unintentionally discriminate. Whatever is your intention in that rule, the actual practice and execution might inadvertently discriminate. So you always want to look at your rules. For those with disabilities, make special adjustments if they are needed because of disability for the person to use and enjoy housing. So I'd like to thank you for letting me present to you today. If you have any questions or want to contact us, our contact information is up there.
Good evening, everybody. My name is Chris Smith. I'm going to change topics a little bit and talk a little bit about the foreclosure awareness. I represent an organization by the name of Neighborhood Housing Services of Phoenix. We're a nonprofit HUD-approved counseling agency. And talk a little bit about the purposes of my presentation tonight is we want to give you a better understanding of the foreclosure-related issues affecting our neighborhoods. My presentation is really geared towards residents, either of Surprise or anywhere in the state of Arizona. We could help you. So. Gain an understanding of the foreclosure timeline in Arizona. There are options for workout. There's a lot of federal assistance here in Arizona, particularly to work with clients to try to avoid foreclosure and give you a little bit of information on working with our organization. Who is NHS? Neighborhood Housing Services of Phoenix. We're a nonprofit HUD-approved counseling agency. We've been in business for almost 40 years. We really do three primary things. We teach, so we offer financial education, financial counseling, home buyer education, so on and so forth. We build, so we do redevelopment of single-family homes throughout the city, and we also lend, so we're also a full-service mortgage banker. Our mission is real simple. It's Neighborhood Housing Services of Phoenix is dedicated to making stable homes and communities possible by educating, building, and lending. Our brand promise is helping hardworking families realize the dream of financially stable home ownership. So everybody knows somebody that has either went through foreclosure or perhaps you've went through foreclosure yourself. So everybody knows somebody that's been affected by this real estate market. And it's really nothing to be ashamed of. There's a lot of people that, there are circumstances that were outside of their control, whether it was unemployment, underemployment, medical related issues. And people just don't really know where to go to get assistance. All of our services are free. We're funded by a number of different funders to help provide this service to the public. We work with families to assist them with their housing issues as it relates to either looking to purchase a house or, in this case, looking to save their home from foreclosure. Because foreclosure is such a major problem, we don't discriminate towards income levels. So we have a lot of clients throughout the city that you would not think that would be coming to us for services, but they're looking for services, they're looking for opportunities and a way out to try to save their house from foreclosure. Our homeownership counselors are nationally trained, so we really know what we're doing. We know how to navigate through the process. Unfortunately, if you're trying to do this on your own, it's very difficult to deal with, say, a Bank of America or Wells Fargo or one of these national banks, because you're going to be dealing with somebody a different person every time you call them. So we have direct access to these banks on a national level to really advocate and submit paperwork on your behalf to try to get a resolution. And all of our clients are assigned to one particular homeownership counselor. So that counselor's job is to really try to navigate and look at the various options that may be available to you and try to get you a resolution as soon as possible. Typically, we average a resolution within 45 to 60 days. So again, if you're trying to do it on your own, you've heard stories where it could take months up to a year to get a resolution with some of the bigger banks. What we don't do is we won't file a lawsuit against your lender. We're not here to act as a legal counsel. We do have the opportunity to work with other organizations such as the Attorney General's Office and Community Legal Services, where there are some options where if you feel like you've been wronged by your lender, there are some options where you could have them investigate that, but we won't do that for you. So here's some resources as it relates to phone numbers and contact information for those entities. And again, a lot of these services are free. In particular, these two services are free and funded by various funding sources. So talk a little bit about foreclosure-related issues affecting our neighborhoods. There's a number of reasons why somebody may go into foreclosure. Past due taxes may be one of them. Maybe you're paying your taxes separate from your mortgage and you haven't been paying your taxes on time for whatever reason. That may be a reason for the lender to start the foreclosure process. Past due homeowners association dues. We see this quite a bit where there are clients that they're making their mortgage payment on time, but they're not making their HOA dues. So that would be a reason, obviously, as you guys may know, that the property could go into foreclosure. Underemployment, unemployment, divorce, death, disability, medical hardships. We're seeing a lot of that now where somebody just had a temporary hardship. Somebody perhaps may have gotten sick and they got 3-4 months behind on their mortgage because they were spending money towards medical bills, and now they can't catch up. And we'll talk a little bit about some of the solutions that may be available to them. And another thing we've seen just really in the last several years is severe negative equity. There have been so many people that bought the properties at the height of the market back in 2006, 2007, and the property depreciated so much where it was worth $200,000 less than what they actually owed on it. So a lot of people decided just to walk away from their properties. And again, we'll talk about some solutions to possibly help you or help somebody that you may know. Talk a little bit about market conditions. Generally speaking, foreclosure filings are down. You haven't heard a whole lot about foreclosures certainly in the last 6 months or so, because you've been talking about the purchase market. There's a lot of activity here in Maricopa County, in particular Arizona, where a lot of homes have appreciated in value, and less people are actually going through foreclosure related issues. However, it still are a lot of people dealing with those issues. According to HousingWire.com, Arizona recently fell out of the top 10 states for foreclosure since the beginning of the boom. So this is really good news, because Arizona is considered one of the hardest hit states in the country. Arizona, Nevada, California, Florida. And for the first time, I think this came out in September, for the first time, Arizona is not one of the top 10 states in the country. Foreclosures here in Maricopa County has decreased by 45% from September of 2012 to 2013. So really good news. I mean, obviously less people are going through foreclosure, but as you can see by this slide, there's still quite a few homeowners here in Maricopa County that still are dealing with foreclosure related issues. So when you put a number to it, in September of 2012 you had 14,500 families or households dealing with these type of issues. Now it's down to 6,500. At the height of the market, that number was up to 50,000 homeowners dealing with foreclosure related issues, where there was filings with the Maricopa County showing that there was a foreclosure proceeding on that particular household. You'll see here in Maricopa County, 1 out of every 886 households actually are currently in foreclosure. And again, this was as of 2 months ago, October 2013. So these numbers are pretty recent. Talk a little bit about the truth about contracts. A lot of people don't realize that a mortgage, when you sign a mortgage, it's a contract. And obviously it's a contract that you enter into as well as the lender enters into. So it's very important that people keep that in mind, because there's been this notion, certainly over the last couple of years, that I could just walk away from the property and just leave it and not worry about it. There may or may not be some consequences of you doing that. So it's very important that you keep that under consideration, that they made a promise to lend you money and you made a promise to pay it all back. So when you talk about the banks and their interest, their financial interests to try to work with you, they're always going to look at their financial interest first to see whether or not it makes sense for them to even offer a workout option to you. So obviously if you break the promise, the lender has the right to demand all of their money back, and that's essentially what the foreclosure process allows them to do, try to recoup as much money as they can through that process. So talk a little bit about the foreclosure timeline here in Arizona. Anytime a homeowner goes to typically 30 to 90 days, that's when you're going to obviously start getting phone calls from the lender. They're going to be, your account's going to be assigned to a collections department within the bank. They're going to be very aggressive to try to get the payment in. Once it goes to 90 days, that's when it's recorded with the public, and what will happen is it goes to a different department within the bank. So then you're going to get a different type of conversation, a different type of letter stating that your file will be referred over to our foreclosure attorney, and then it becomes much more expensive as it relates to costs associated with that process to get it out of foreclosure. So a lot of people don't even really understand this. It's very important to understand, because some people may only be 2-3 weeks late on their mortgage, and they have never been late on their mortgage before. And what will happen is they panic, because I've never been late on my mortgage. Am I going to go into foreclosure? Unfortunately, you won't go into foreclosure in that situation. Really, the key time frame is 90 days from the payment being due is when that process is going to start for foreclosure. So you talk about some solutions. Obviously, the most common solution to foreclosure related issues is a modification, where the bank really agrees to modify the loan and make it more affordable based on your income and your hardship and so on and so forth. Some people decide to just short sell the property and sell the property for less than what it's owed on the property. Some lenders will allow you to do a deed in lieu of foreclosure, where you basically give the property back in lieu of a foreclosure. When you talk about the options and the way the bank evaluates you on whether or not you are eligible for these programs, it's really about the math. Do you qualify based on your income? and whether or not the bank determines it's going to be more profitable for them to take the property back in foreclosure versus giving you a modification. It really comes down to those two equations as it relates to whether or not they're going to modify the loan or work with you. One of the key components that they look at is whether or not your payment is 31% of your gross income. So when your payment is affordable, it's typically 31% is the industry standard as far as being affordable based on your gross income. If your payment is more than 31%, it may be considered unaffordable. What will happen is at that point in time, they will look to possibly give some workout options to you based on your individual situation. So there are some instances where a client may have purchased the house and their payment was always unaffordable. You know, you saw a lot of that back in 2006, 2007, 2005, where these lenders were giving loans based on unaffordable payments. Well, the bank may or may not work with you because technically your payment was always unaffordable based on these rules here. So again, so just to do a quick math example, 31% on a $3,000 a month income is $930. So if you, again, if your payment is under $930, they're going to consider that payment already affordable. What will happen, a lot of people, as I mentioned before, are having medical related issues and they had to allocate their money towards medical issues or medical expenses and they did not make their mortgage payment. Unfortunately, some of the banks and some of the processes that we look at, they don't really care about that. They really care about their mortgage payment and whether or not it was paid on time. So when you look at various options, you know, really there's a couple different options. There's a reinstatement, so you could, if you're $4,000 or $5,000 past due, you can either scrap up the money, take it out of a 401k, get the mortgage back on track, get it out of foreclosure. As I mentioned before, once it goes 90 days and it's referred to a foreclosure attorney, those expenses increase by $3,000 or $4,000 depending on the fees that the attorney actually charges. Repayment plan, so you can work with the lender, say, okay, we're going to pay extra payments on a monthly basis for the next 6 months to try to pay this past due amount off. A lot of times lenders will work with you if you're less than 6 months past due. Payment forbearance, where they take the past due amount, they just basically put that on the backside of the mortgage and say, okay, we're going to get you current, but you still got to worry about this at some point in time in the future. And then a loan modification, which is a lot of times the most common workout option. A modification really allows you a couple different things. It could allow you to extend the term of the loan. It could allow you to do a lower interest rate. Have a lower interest rate rather. It could also allow principal reduction. We've seen a lot of transactions in the last year or so where the banks actually just forgave the principal, and we've seen some significant amount of principal reduction, especially here in Arizona in severely hardest hit areas of the city, where the bank said, okay, we're just going to reduce it so much and forgive $100,000 worth of your principal, for example, and you know, get you back on track. So disposition. That really goes to, if you can't qualify for a mortgage, what are your options as it relates to, you know, disposing of the property? You could do a straight sale. So a lot of people, unfortunately, a lot of people in Arizona don't have equity in their property, at least the people we deal with on a day-to-day basis. So they have a severe negative equity or a negative equity position. So the straight sale really doesn't apply to a whole lot of people. However, a short sale will. So a lot of people will decide after they go through the process and try to get a modification or a workout option or other sort of programs that they can't or they are not qualified for those programs, the next step in the process is to look to possibly do a short sale. As I mentioned before, a deed in lieu is also an option. And then the last option is, what you really want to avoid, is a foreclosure. You know, so if you can't qualify for anything else, you want to try to dispose of the property gracefully and exit out of the property via a short sale or a straight sale. Couple different major programs that are offered here in Arizona. The first one I'm going to mention to you is the Save Our Home AZ program. This program has actually had a lot of criticism over the last year or so because the state of Arizona actually has over $200 million that they still need to spend under this program. And what they've done recently over the last 6 months or so, they've reallocated a lot of that money to help homeowners that are not necessarily dealing with foreclosure related issues, but more so homeowners that actually have a negative equity positions. And they're allocating up to $100,000 for a principal reduction in conjunction with a refinance. So that may be an option for some of you that may not be dealing with foreclosure related issues. You've been making your payments on time, you could afford your mortgage, but you're upside down as it relates to how much the value of the property is compared to the mortgage. We've helped several clients access up to $100,000 in principal reduction. The goal is for you to keep the property for at least the next 5 years. So the state doesn't want to give you the money and you sell the property 6 months from now. So there's some promissory notes that you have to sign saying that you're going to keep the property for the next 5 years. Some of the other programs that they offer is unemployment, underemployment assistance, second lien elimination, HOA elimination. So if you have a client or a homeowner that actually had a hardship and they were negative on their homeowners association dues, if they get back in a position where they could actually afford the mortgage, this program will actually pay off the past due HOA dues. Another program is the Making Home Affordable program. This program has been around since 2009, and it was part of the Obama administration, basically to help homeowners get more affordable payments. There's certain banks that actually have to evaluate clients for this particular program before they look at any other programs that they may offer the client. So we're very active with this program as well, very well versed in the program. They also offer a home affordable refinance where you could refinance the mortgage regardless of your payment history outside of your mortgage. So if you've been making your mortgage payment on time and you've had some issues with car payments or credit card debt, you could take advantage of the lower interest rates, because there's still a lot of people out there that did not refinance their mortgage because they were upside down on their property. And a lot of people still actually have interest rates around 6.5%. Right now rates are in the low 4s. So you may have an opportunity to refinance the mortgage and get a lower payment. And then the last program I want to mention is the Arizona Mortgage Relief Fund. This is a program that we actually administer on behalf of the Attorney General's office. And we administer $20 million for the state of Arizona, where we help homeowners with reinstatement. So again, if you've had a hardship where perhaps you had a medical issue and you just can't get back on track, this may be an option for you. There is a principal reduction component under this program where you could access up to $60,000 in principal reduction to drive down the principal of your mortgage. So second mortgage payoff is one of the other options under that program. So for all the programs, what we do is we sit down with you on a one-on-one basis. We actually, it's very comprehensive. The first initial appointment probably take 2 hours, and we'll sit down with you and really dive into your hardship. What was the cause of your hardship? What was the circumstances as it relates to your income when you purchased the property? What's the income looking like now? Does it look like you may or may not qualify for one of these programs that's offered through the state or through your lender? We don't make the decision. We just help you actually process the paperwork in a more efficient way. As I mentioned before, if you're trying to do this on your own with the lenders, it's very difficult to do that. So we actually have direct line of communication, certainly with the big major lenders, where we have a department that we work with directly to really hold them accountable to get a decision on your file sooner than later. Very important when you talked about principal reduction, there are lenders that are, as I mentioned to you, are doing principal reduction, but they will send you what's called a 1099-C at the end of the year, which may cause some tax implications. So obviously you would have to talk to your your tax professional, see how this would impact you personally. But there's been a lot of people that have been bitten by this, where they get $100,000 in principal reduction, but that year they get a portion of that $100,000 in a tax bill as additional income, which they got to pay taxes on. So you don't want that to sneak up on you if that is the case. Expectations, really, when we sit down with clients, is we're working with you and not for you. We're not going to we're not going to care about your house more than you care about your house. So it's important that you submit paperwork to us in a timely manner so we could get the information over to the lender. It's important that you keep your information current. So a lot of the banks and lenders require updated pay stubs and things of that nature. We also require that you call your lender every 7 days and check the status of your modification, so on and so forth. Because we have a lot of clients we deal with on a daily and a weekly and a monthly basis. So we put the onus on the homeowner to really kind of be proactive in that situation. So there's my phone number to the office if you know anybody that either wants to take advantage of some of the programs that we offer, but in particular the principal reduction piece. There's a lot of people that don't even know about this, and you know, you could Google it. $200 million that the state of Arizona still has to spend by 2017. So if you're in a position where you've been making your mortgage payments on time, you may be eligible for the principal reduction. I need you to call our office so we can start talking to you about that conversation. All right? Thank you.